Mr. Barron.
May it please the court. Counsel, my name is Joe Barron. I represent the Appellants, Bridgestone, Firestone, and Old Republic Insurance Company. This is a workers' compensation case. The claimant, Bruce Baker, works in the maintenance department at Firestone. He had a traumatic injury on May 23, 2010, when he stepped on a lanyard. It was attached to him, and he tried to straighten up. He injured his back. He said he felt a great deal of pain at the time. He reported the injury to his supervisor. He began treating with Dr. Troll, who gave him medication and a restriction to work at his own pace. That restriction was never lifted, and the claimant testified, Mr. Baker testified, that the pain never went away and it never decreased. Under Iowa Code, Section 85.26, the statute of limitations is 2 years in this case. The petition was filed on June 20, 2012, and the commissioner ruled that the claim was barred by the 2-year statute of limitations. Now, the issue in this case is whether the statute of limitations is told by operation of the discovery rule. The claimant's counsel would argue that the sole issue in this case is whether we apply the discovery rule to traumatic injuries. We don't think that really is the issue here. It's just not that simple. The issue isn't whether we apply the discovery rule to traumatic injury cases. The injury is what discovery rule do we apply. In Herrera, this court addressed the application of the discovery rule to cumulative trauma injury. The court used the basic test, the standard test, very well known, that says the statute of limitations does not begin to run until the claimant knows the nature, seriousness, and probable compensable character of the injury. However, for that cumulative injury case, the court said for the statute of limitations to begin to run, the claimant must know or should know of a permanent adverse impact on the employment. And I think that goes to the heart of the issue in this case. That requirement that obviously is directed toward the seriousness component. I want to back up just for a second. In the workers' compensation arena, that's what we refer to as the discovery rule. We talk about the discovery rule, we talk about Herrera. They just go hand in hand. And so what I mean by that is when the commissioner in this case said we don't apply the discovery rule to traumatic injuries, he was referring to Herrera. He meant we don't apply the Herrera discovery rule to traumatic injuries. I think he was absolutely correct in that regard. We see that in the work comp decisions in this case, we see it in the district court decision, and we see it in the claimant's brief. The problem with this is Herrera is not the standard for traumatic injuries, and this is not an issue of first impression. In Swartzendruber versus Schemmel, this court addressed, and that came down at about the same time as Herrera. One was in 2000, one was in 2001. This court addressed application of the discovery rule to traumatic injuries. Used the same basic test, that the claimant knows the nature, seriousness, and probable compensable character. But as to seriousness, the court differentiated between pure latent injuries and what is referred to as a traumatic event latent manifestation injury. Pure latent injury is where there is an event, but no known injury. And the classic example is the exposure to hepatitis C from the Perkins decision that's discussed in the briefs.
How do you classify the injury in or? Latent or traumatic?
The claim, as I remember, the claimant in Orr was struck on the neck, and that was a case from 1980. The claimant was struck on the neck and claimed headaches, and I think that the claim was that he didn't know the seriousness of the injury, and this was the first manifestation, I guess, or the first time that the court said we're going to apply the discovery rule.
Well, it certainly fits your definition of traumatic, doesn't it? A plank falls down and hits him in the back of the neck.
That would be the traumatic. That would be the event. it could be could still be a pure latent injury or could be a latent manifestation, because even in a pure latent case, there is an event. There is a single event, but then something that there's no known injury at all, and then something appears later. I don't know, there was a plank that struck the claimant on the neck. To me, that sounds more like a latent manifestation case.
Well,
How about in the Rude case, where you have somebody who has a shoulder injury that seems to have been caused by a traumatic incident and then progressed over time, even though it really didn't affect her employment, is my understanding, and then the discovery rule seemed to apply to that one, didn't it?
Again, I think the issue in this case is which discovery rule, but in Rude, I would say that's not a Herrera. The Herrera rule was applied in Rude, but in Rude, it was a dislocated shoulder that seemed to dislocate again and again, and it wasn't really clear, as the commissioner noted, that whether or not that was really a cumulative injury or a single traumatic injury. But I would say that the issue in that case that was before this court was really just a substantial evidence issue, because the Herrera rule was applied. It wasn't raised as an issue whether it should be applied, and the court said substantial evidence supported the finding under the Herrera rule. It wasn't.
Mr. Barron, let me try this out on you. I mean, I understand that there's maybe with the commission, there's this, they see that we've made some distinction between traumatic and other kinds of injuries. But as I read it, the problem I have is I read Herrera and I read Schwarzenruber, and they're a year apart. The formulations of the discovery rule, the language is somewhat different. And then Herrera, which comes second, doesn't discuss Schwarzenruber, so it's not especially helpful in that regard. Maybe what we should just do is kind of dig into that language of both cases and figure out what is really the discovery rule, and then just apply it here, rather than make these sort of what seem to be maybe somewhat artificial distinctions between traumatic and cumulative and so forth and so on. Would that approach make sense?
It may. I mean, we do have precedent here that diverged, and it diverged strictly according to whether it was a traumatic injury or a cumulative
Who knows
injury.
why it diverged? It's just there is different language, and the second one doesn't discuss the first.
Right.
I mean, and that happens. I've done that in my cases that I've written sometimes. But one reason we have the third case is to figure out what we meant in the first two, right?
I would say, Your Honor, that although those cases, obviously Herrera doesn't discuss Schwarzenruber, I think those cases do make sense. I think it works.
I agree they make sense, but some of the language is a little different.
Might they have different discussion of the discovery rule, those two cases, because Herrera was clearly a cumulative injury case and Schwarzenruber was not clearly a cumulative injury case?
I would agree. I think Schwarzenruber was clearly a traumatic injury case, and because of the peculiar nature of a cumulative injury, it made sense to say we're not going to hold a claimant as a reasonable person to knowledge that they should go ahead and investigate until they know what's going on. Because in a cumulative trauma case, you don't even know when there is an injury or what it is. It's something that happens gradually. It can just be some symptoms that kind of come and go and maybe start getting worse. It makes sense to me that the average employee just doesn't know what's going on. So we say, look, until it's really impacting your employment, and you should know that it's a permanent impact on your employment, we're not going to hit you with that clock ticking.
And we in Herrera, we separate the prongs of the analysis, right? Yeah. The first prong is, in that case, in Herrera, we say the first thing we do is we look at the manifestation, and we determine when the injury manifested, and then we apply the discovery analysis, right?
Yes, Your Honor.
So my question is this. Clearly, the discovery rule is a judge-made, a court-made doctrine. to ameliorate the harsh consequences of a statute of limitations in circumstances where it just doesn't seem right, doesn't seem fair. So my question to you is this: is there really any good, intellectually honest, defensible distinction in the application of that fairness doctrine, whether the injury is a cumulative injury or based upon a single incident, such as Schwarzenegger or some of these other cases?
Or this case, Your Honor.
Yeah.
I think there is. I think there is, because both Schwarzenegger and Herrera still applied the basic test: nature, seriousness, and probable compensable character. So what we have in a traumatic injury such as this is a known compensable injury. And it goes back to the purpose of not only the statute of limitations, but the purpose of the discovery rule, which is not to extend the statute of limitations. The purpose is to prevent stale claims. And where there is a known compensable injury, such as we have here, then the claimant has 2 years to investigate and file their petition, or 3 if weekly benefits are paid. That, to me, does make sense, as opposed to a cumulative injury case where, as we've discussed, it's difficult for your average employee who's not in the work comp field to even know how their symptoms might relate to work comp, or the fact that over a number of years, many years, their back is just hurting. And it used to hurt once in a while, now it hurts all the time. And to me, I'm not saying I know exactly what that cumulative trauma rule says, but I think Herrera does make sense, or some sense, in that instance, just because
Can we write one formulation that then leads to that result that you described in each of the 2 cases, instead of having 2 cases that don't talk about each other?
It may be. I don't know what that one formulation would be, because I do believe there is, in this case, for instance, if the court were to say, here's how we're going to treat these types of injuries, here's how we're going to treat these types of injuries, certainly, that could be done. I don't know what that would say, but I do think they should be treated differently. I don't think there is a one-size-fits-all here, because again, going back to the purposes of the discovery rule and the purposes of...
Obviously, it's going to be easier for the employee to have notice in the traumatic situation than in the cumulative situation. You don't really know whether what you've got is related to your work. You don't know if it's really interfering with your work. You don't know that. And
Absolutely.
So you could, it seems to me, you could have one rule and apply that rule equally in the 2 situations and get 2 different results.
It could be, Your Honor. I don't know. I don't know what that one rule would say while preserving some distinction.
I don't
between
either.
the 2.
So.
The one reason I think it would not be logical.
There's no, in listening to the argument, there's no question that you think Herrera was decided right, and when you have a cumulative injury, the statute will begin to run based on the series of injuries when it culminates to a serious injury.
I, for purposes of this case, sir, I do believe that. Personally, I think Herrera went a bit far. I don't think it should really be necessary that there be a permanent adverse impact on employment, because even in a cumulative injury case, you don't have to have a permanent adverse impact.
But work comp is different than other areas, because until you're off work or until you seek medical care, you don't get any compensation. It's not like the car accident where you're not depending on some system to compensate you. And I sort of have the same problem Justice Mansfield has, that if we're doing this until the injury affects you under the work comp system, why shouldn't the Herrera discovery rule do the same thing? Because they're not getting, the employee is not getting any benefits, he's not getting any, or he or she's not getting any healing period, not getting any medical pay, not getting any of that stuff until the injury actually causes him or her to be off work. And it seems, at least in the at least in the work comp area, until it manifested stuff so you're entitled to some benefits, don't think the statute should begin to run. I mean, is that so unfair in a system where it's based on benefits by the employer, I'm sorry?
I think that would essentially abrogate the statute of limitations. We do have 8526. There is a 2-year statute of limitations. And frankly, for most work injuries, there is no resulting permanent disability or permanent adverse impact on the employment. And so if we say you have to reach that point before a statute of limitations even begins to run, then I believe what you're really saying is in most cases, for most work injuries in Iowa, there is no statute of limitations because there'll never be that point.
Well, he did receive some benefit. I mean, he received medical care paid for by the employer at the time of this injury, correct?
Absolutely, and he was aware that this was a compensable claim. Not just that he had a problem, he was aware this was a compensable injury because of that. Thank you very much.
Thank you, Counsel. Mr. Ozga?
May it please the court, counsel. The fundamental dispute before the court in this case is whether the discovery rule applies to injuries which are traumatic in nature. And given the questions that have been asked so far today, I mean, in my opinion, it would appear as though, I mean, it's my belief that there should be only one discovery rule that would apply to both traumatic and cumulative types of injuries. And I think that discovery rule has been developed over the course of time to talk about whether the claimant knew the nature, the seriousness, and the probable compensable character
Well,
of
let's
his
take
injury.
your argument and let's change the facts a little. Let's say this happened from a car accident. And again, Mr. Barron hit your client, and it's not a work comp injury. Would your same argument be under the discovery rule? It wouldn't run until, although he was treated, although he had some injuries, some pain, it wouldn't be compensable until such time as he knew the total extent of his injuries in the car case? Because I don't think you can separate this discovery rule for purposes of work comp and for other areas of the law unless the legislature has a special statute.
I think you can separate it. I mean, workers' compensation is a special statutory creature, and I think it can be the rules that are applied to workers' compensation, I think, can be segregated from a personal.
But can't we apply the discovery rule as we use it in a tort case for a traumatic injury? In that, you know, once you know you've been injured and you have a date you were injured and you had some treatment but don't know the full extent of your injury, your statute begins to run. Because that's when you knew or should have known that there was something wrong with you. And I could see the difference for a cumulative injury because that's a whole different animal. But I don't know, I mean, tell me a reason why in a tort case and a comp case it should be differently, because there's still liability, still someone has to pay. And in fact, in a comp case, you're on the hook a lot longer than you are in a tort case. Because in a tort case, 2 years you're done, and you have to decide with the injuries in the future. You always have the right to reopen in a comp case. So why shouldn't we have that statute of limitations applied the same way in a personal injury case outside the comp system and inside the comp system?
I think in a comp case there are unique things about a comp case that wouldn't apply in a personal injury in terms of in terms of whether this is going to be permanent, in terms of the person's work, whether it permanently affects that person's work. I think some of those things are things that are not necessarily going to be involved in a personal injury.
But we require
type
that in a
action.
personal injury case when you don't know what's going to happen to you, and if it's tried, you can't reopen it.
Right.
I mean, I used to always tell juries when I argued, I like to come back every 3 years and we give them more or less money because of what happens, but you got to decide now.
Right.
So, I mean, the same things have to be made, and it seems to me that there has to be some cutoff of a claim when the
Well, and
claimant knows
I think
it
there is
should
some
have known.
cutoff of claim, Your Honor, in terms of the individual involved has to know the nature, seriousness, probable, compensable character. And, I mean, at that point, once that date is established, then the claim is going to be cut off 2 years after that point.
Counsel, I'm sorry. Isn't the workers' compensation regime, the arrangement, vastly different than other areas of civil litigation and different in ways that provide a legitimate basis for the court adopting the discovery rule in workers' comp cases as it did in Orr?
I think
And
that's
tell us
correct.
why you think that.
Well, I think it's because in a workers' compensation case, I mean, there are certain things that one has to prove, and I think that one of the things that a person has to prove or that a person has to know is that this is going to have some kind of permanent impact on that person's employment.
Isn't it broader than that in the sense that the legislature saw fit back in the 30s to take workers' comp out of the civil litigation and tort area and created a separate universe
Well, and
where
even before
where the relationship between employer and employee is very different than the relationship in the civil litigation context between tortfeasor and victim.
I would agree with that.
Okay, and isn't that, do you feel that that's a sufficient basis for recognizing a discovery rule in the comp arena that is not recognized in other civil litigation, and if so, why?
Well, I believe that because it is a statutory scheme that has its own rules, that the decision as to whether to apply some type of discovery rule is based on that statutory scheme, and the unique aspects of the comp system lend themselves to the application of a discovery rule that may or may not be the same as what's applied in personal injury actions.
Let's do this then. You would agree with me that if we were to apply the personal injury or the normal discovery rule, your guy would be out. Because he knew of the injury, he got treated that day, he didn't know the extent, but he'd be
No,
out.
I wouldn't concede that.
Well, where's the case, tell me a case where we applied the discovery rule in another way in a personal injury case.
I'm not sure in a personal injury case. I mean, I would say in this case, to my way of thinking, is Orr. Orr had a specific injury, or it's Midwest versus Rude. I think both of those cases were cases where you had a traumatic injury, and the claimant did not know the full extent of those injuries until well after that.
I'm talking about in a personal injury case, though.
Okay, well,
I think-
I apologize, Your Honor, I'm not as
I
conversant
think,
with personal
unless
injury.
I'm wrong, and I've been wrong before, but once you know the injury and that you had medical care, your 2 years is going to run them if you don't know the extent of the injury. And you said something in response to Justice Heck's question that sort of threw me a loop. You said you don't have to do it until you know it's permanent. So are we going to have like two separate statute of limitations? One for non-permanent injuries where you want to get your healing period and your medical bills reimbursed when they won't do it. And another one, when there's a permanent injury, that only runs from the time you know it's permanent.
No, I don't think, I think in terms of the injury itself, you have to know the nature, seriousness, and probable compensable character. And in Larson versus Thorson, this court found that not knowing that the injury was permanent was a part of that probable compensable character of the injury.
Let me ask you, let me just read this language from Schwarzenegger. This is what we said. The duty to investigate begins once the claimant is aware of the problem. Under this standard, the degree of knowledge is based upon a possibility, not a probability. Thus, if it is reasonably possible an injury is serious enough to be compensable as a disability, the seriousness component of the test is satisfied. Do you agree with that language, or are you asking us to scale back on it?
No, I would agree with that language. I would agree with the language that the court has used. I'm just suggesting that in the context of this case, and actually in the context of this case, we don't even know what's going to happen because the commissioner never applied the discovery rule because they said it's not going to, can't apply to. So in any event, this case is going to have to go back to the commissioner for a determination.
And I want to follow up on the permanency issue because it, you know, from what Justice Mansfield just read, it seems like what you need to know or be on notice of is that it's compensable. Is it your position that no, the clock doesn't start running until you know it's, or should know it's permanent? Or is it merely that it's compensable?
And that's a distinction that I'm not sure what the distinction is between permanent and compensable. I think in this case, I don't necessarily know that you have to have a permanent impairment rating or something of that nature, but you do have to know that there's a permanent impact on your employment in order to meet the discovery rules.
Well, when did that event occur in this particular case? Because my understanding is that the individual was continuing to work, did continue to work, and really in May, I think it was, of that whatever year we're talking about, then they simply come in and say, well, since you didn't file any type of claim or a contested case, then we're no longer responsible for you, and basically dropped him. Isn't that the understanding? But if I'm working all the way through that time, and my understanding as well is that he did get the medical care, but he never got paid for any time off or any of these things. So when did the compensable nature of my injury then manifest itself otherwise?
It was our argument before the commissioner that happened in approximately December of 2010 when Mr. Baker began having more and more medical treatment, when he was referred to a specialist for pain treatment. He finally got, it wasn't until December of 2010 that he had any type of testing, no x-rays, no MRIs, nothing was done before that time. So that was our argument before the commissioner.
So it's not a continuing running of the clock, so to speak. You're saying that was the specific date when he knew or reasonably should have known that he had a compensable injury, is it December of 2010?
Yes, Your Honor.
Okay,
But
thank
you lost on that factual point, right?
Not
I'm
sure.
reading from the fact findings below. These facts establish that Bruce thought the injury serious prior to June 2010, or at least he should have realized its seriousness before that time. I'm reading from, I think it's the arbitration decision, which was adopted by the commissioner, at least at that point, page 4. So you lost on that point, right?
No, I don't think we did, because there was a later discussion in the same arbitration decision where the deputy seems to indicate that he thought that the claimant did not know the probable compensable character until the summer or the fall of 2010.
Well, I think if I can follow up on Justice Mansfield's question, I mean, I think your ship's passing in the night because his question relates to the claimant's understanding of the seriousness of the injury,
Right.
and I think you're talking about
Probable
the
compensable
compensability. There are 3 prongs of this analysis, and Justice Mansfield's pointing out, I think, that one of the 3 prongs is perhaps addressed by Mr. Walshire, and suggesting that seriousness might have been apparent
I
earlier.
would agree with that. I mean, he
Yeah.
certainly said that, yes.
Well, Mr. Ozga, where does the date of the occurrence, which is the language under the statute, where does that come into play?
The date of the occurrence, I think, comes into play in this case after the application of the discovery rule. I mean, certainly the occurrence, the traumatic injury, just as in or, occurred on a specific date on May 23 of 2010. But the date for discovery rule purposes would not be until sometime thereafter.
So when was the injury date in this case? Do we have to,
May 23 of 10.
and that's the date of the occurrence for which benefits are claimed?
Right, right.
Well, I want to follow up on that. Are you conceding that the injury for which your client is seeking compensation occurred for discovery purposes
No,
on
no,
May 23rd?
definitely not.
Okay, I think
No.
that's what your answer was.
No,
So if
I'm not conceding that for purpose. Again, I think the date of injury for discovery rule purposes is the December of 2010, as I'd indicated previously. In terms of what needs to be done with this case, as I had indicated before, I don't think, because of the way that the commissioner discussed things in this case, they applied the Clark versus Spencer case to indicate that it didn't apply to specific traumatic injuries, and I think that's wrong. And
Let
go
me
ahead.
follow up one more time then. What occurrence took place in December of 2010 to describe an injury that you now seek benefits for?
A vastly increased amount of care for claimants, particularly for the injury that he had to his back. He began seeking care. He had 4 treatments in December. He had x-rays. He was referred to a specialist.
So the medical treatments that occurred during that month was the occurrence that predicated
That allowed him to,
benefits?
for which he met the discovery rule. Yes, Your Honor.
I think you were just briefly mentioning Clark. Why is the commissioner's reliance on Clark inappropriate in this case?
There's actually-
Clark is the agency decision, right?
Right, right. There's actually a couple of reasons in Clark, and Clark actually claimant had been paid, and so factually the Clark case is quite a bit different than what the commissioner cited it for. We think that Clark and its progeny, there's a number of cases following Clark, all of which say that the discovery rule is not applicable to cases that involve a traumatic injury. We believe that's inconsistent with Orr and a number of the other cases, including Midwest Ambulance versus Rude, which we cited in our brief, Your Honor.
So are you saying that in Clark there was a totally different statute of limitations
Yes,
that
I believe
controlled?
there was, yes.
And one to which the discovery rule has no application?
That's right, Your Honor. Thank you, Your Honors.
Thank you as well, counsel. Mr. Barron.
If I could, I'd like to touch briefly on the ships passing in the night discussion. When the commissioner said, I believe that the claimant did not prevail on that issue. When the commissioner said that the claimant didn't know he had a permanent adverse impact on his employment until the summer or fall of 2010, the commissioner was talking about the seriousness component, not the compensability component. That is the Herrera standard also. Basically what the commissioner was saying is, I think implying that if the pure Herrera standard is applied to this case, the statute of limitations would not have run. But the commissioner also said the claimant was aware that he had a serious injury prior to June 20, 2010, which means under Schwarzenegger, the statute of limitations did run. It is the seriousness requirement where those two cases diverge. And
This is where the ship's passing in the night, not the findings by the commissioner.
I think the cases treat traumatic injuries different from cumulative trauma injuries. And one they are not cases that should be similar because the cases before them are different, in my opinion. We're not asking for anyone to overturn Herrera. I think it went a bit too far because I don't think a permanent injury should ever be required before the statute of limitations begins to run. But that's not the issue here. It's certainly not the argument we're making. Most compensable injuries are not permanent. And so to me, it's very confusing when the discussion is, well, when did the claimant know he had a compensable injury? Well, that is certainly not when the claimant knew he had a permanent injury, or there's no reason to necessarily tie those two together. We'll go back to the common law. At common law, all that a plaintiff needs to know is know or should know the essential elements of the claim. Well, an essential element of a workers' compensation claim is not permanency. It is not a permanent impact on the employment. Essential element is arising out of in the course of treatment, and then if you're going to say compensability, medical benefits are compensation. They are a med-only claim, which probably is most of the claims in Iowa. A med-only claim is every bit a compensable claim as the perm total. It's compensable. They're both compensable. when the Herrera's test is applied, as it's been applied since 2001, it has always been applied as a requirement of a permanent adverse impact on the employment. And 2 months ago, the Iowa Court of Appeals in Menard versus Simmer did exactly that. This court did that in Larson versus Thorson, which is cited all the time. It's a requirement of a permanent injury, a permanent impact. What if we apply that to every injury, or every traumatic injury where the claimant knows it's compensable? I'm not talking about the pure latent injuries where the claimant is in the dark completely. There's a great deal of fairness in treating that the way Schwarzenegger did. But if we're going to treat all traumatic injuries as having no statute of limitations until it's permanent, then we really are we might as well just get rid of 85.26.
Well, I guess I just want to make a comment on something that you just said, which bothered me a little bit from a discovery rule standpoint. You said that even a med-only claim is a known compensable injury. Well, then why do we ever have any discovery rule? If right now, anytime you've been injured, whether it's traumatic, cumulative, I don't care what it is, and once you've now obtained treatment from your employer, then you now have already met that standard of a known compensable injury. So are you saying that's already met in all these cases?
No, because there still is there's still the three prongs. Yeah, you have the nature, seriousness, and compensable character. I'm just saying I don't think we should confuse compensability with permanency, or compensability with the claimant not being able to work. A typical broken arm, case, very run of the mill. An employee has a broken arm. There's a cast put on it. They treat. May go back to work light duty, maybe not. Eventually, the cast comes off, the treatment's done, and life goes on. That was a compensable injury. There's no question about it. And to say that the statute of limitations never started because the claimant never knew or should have known of a permanent adverse impact just means there's no statute of limitations. Thank you very much.
Thank you as well. The case is submitted. We'll now hear the arguments and concerned citizens.